Hi, everyone. My name is Jessica Chandrashekar. I'm an immigration and refugee lawyer. And today I'll be speaking with you all about humanitarian and compassionate application. And I'd like to begin with a land acknowledgement. Toronto is on the dish with one spoon territory. The dish with one spoon territory is a treaty between the Anishinaabe, Mississaugas, and the Haudenosaunee that bound them together to share the territory and protect the land. Subsequent Indigenous nations and peoples, Europeans, and all newcomers have been invited into this treaty in the spirit of peace, friendship, and respect. So, I'm really honored to have been invited to speak with you today, and many thanks to the organizers for having me. So today I'll be speaking about humanitarian and compassionate applications, and I'll call them H&C applications for short. H&C applications are applications for permanent residence that are made by people who don't qualify for other pathways to permanent residence in Canada. There's a fairly recent case by the Supreme Court called Canvasamy, and in that case, the Supreme Court went through the whole history of how these applications came to be, and they identified a case from 1970 called Chirwa, where humanitarian and compassionate considerations were first defined. In that case, keep in mind, it's from 1970. Humanitarian and compassionate considerations refer to those facts established by the evidence which would excite in a reasonable person in a civilized community a desire to relieve the misfortunes of another, so long as these misfortunes warrant the granting of special relief from the effect of the provisions of the Immigration Act. So, I mean, a little white savior sort of language there, but really what it means is that these applications are meant to provide a pathway for people who are in, exceptional and compelling situations and who may not fit in within any of the more rigid pathways to permanent residence in Canada. And so before I start, I just want to make very clear that this presentation is just it's very general. It's just a general overview. It's not legal advice. If you'd like to speak about your specific situation, I'm more than happy to speak with you one-on-one or to give you a referral for someone else who can speak about your specific situation, and to see whether or not this would be an appropriate application for you. And my presentation is structured in two parts. First, I'm just going to provide a summary of all the moving pieces of these applications. And then I will provide an overview of how the applications are assessed. And it's important for anyone who's considering these applications to have this information for a couple of reasons. The first reason is so that you know how much work is involved in these applications, and I'll tell you, it's a lot. I spend hours on these applications. They're most often done by people who don't have status or who have temporary status and are seeking permanent status in Canada. And obviously people are very eager to get their applications in and completed as soon as possible. And what I always try to explain is it's important to balance between making a timely or quick application with making a strong application. And sometimes these two things are not compatible. But think about what I tell my clients is I say, think about when you had an exam in school. Did you receive a better grade when you put a lot of time into studying, or when you just sort of started studying the night before the test? Good results take time and a lot of work. And so another reason why it's important to know the information I'll be sharing with you today is so that you know what should be going into your application, just in case the person who is assisting you, whether it's a consultant, a lawyer, paralegal, isn't doing that. And that happens. I've seen applications that could have been strong had the right evidence been submitted or had more time been spent on the application. It's important for you to fully understand what's necessary to make your application strong, because it's your life. And at the end of the day, the result of your application will impact you. It won't impact your lawyer. And so it's important that you work with someone who you trust and who you believe will put in the time into your application to make it strong. And I know that it can sometimes be difficult or intimidating, but it's really important to ask your lawyer questions and voice any concerns you might have with their representation, because it's your life. Okay, now moving on to the components. There's several components to these applications. There's several forms you'll have to fill in. There's required identity documents like birth certificates, marriage certificates, passport-size photos. There's an application fee. These are all required components that are set out in the document checklist that's a part of the application package. There's also really important components that you should provide that aren't listed in that document checklist. And the most important and critical is a sworn statement that sets out your reasons for making an agency application. An agency application is paper-based. So everything is just compiled and put in the mail and sent off. There's no right to a hearing or interview like other immigration applications, like a refugee claim. So your sworn statement is your opportunity to have your voice heard and to share your story. And so it's really important that that sworn statement is as detailed as possible. Next, you should collect evidence that supports your sworn statement. This is referred to as subjective evidence because it's evidence that is personal to you from people who know you. The evidence can include letters from family and friends. It can also include evidence confirming your employment history, a letter from your doctor, a letter from the church you go to, any community organizations you're a part of. If you have children who are dependent on you, you should provide evidence of that, for example, money transfer receipts. The evidence is very specific to your case. So, one example is if you're applying for permanent residence, and one of the reasons why is because you provided evidence to support a complaint against your employer and workplace conditions as a migrant worker, then you should provide a copy of that complaint or evidence. The lawyer who helps you with your agency application will provide you with a list of evidence that you should collect, a list that is specific to you. And in addition to this personal evidence, your lawyer will also include evidence they found by doing research. And that's called objective evidence because it supports the larger claims you make in your sworn statement. But this evidence isn't by people that know you personally. Examples of this kind of evidence can include human rights reports, newspaper articles, academic studies, and they also support whatever you say in your sworn statement. For example, if one of the reasons why you want to stay in Canada is because you're from Mexico, and there's a lot of extortion by cartels in the region where you live, and you're unable to find housing outside of that region, and it'll be difficult for you to make ends meet while also possibly having to pay these extortion fees, then it would be important to provide evidence of that. If you're from the Philippines and there's a very high unemployment rate, you can provide reports that speak to that as well. This evidence is important because it's hard, if not impossible, to show that if you went back to your country of nationality, something will happen to you because you've not returned to your country of nationality. You're still in Canada when you're making these applications. But the objective evidence, so these reports or newspaper articles, can show that there's a strong possibility that these things might happen to you if you do go back, because it's happening to other people who are similar to you in your country of nationality. And please let me know if that's confusing. And so the very last piece that's involved in these applications are legal submissions. And they're written by whomever is assisting with the application. The written submissions argue why your humanitarian and compassionate application should be accepted, and it makes reference to the evidence you submitted. They almost work as a guide for how, or a roadmap for how the officer should, parse through everything that you've submitted. Now, in terms of how are these assessed? After you've submitted all of these things, how are they assessed? Well, it's an immigration officer who assesses your application, and they largely just look at two things: your establishment in Canada and the hardship that you would experience if you had to return to your country of citizenship or nationality. And so your sworn statement, back to that sworn statement that's so important, should really provide a lot of details about those two factors. So in terms of establishment, this looks at your life in Canada and asks, do you have strong ties to Canada? Have you been living a life in Canada that's similar to that of someone who is a permanent resident or citizen? I mean, how hard is that, right? It's really difficult to build strong ties to Canada when you are not a permanent resident or a citizen. And it's especially difficult to do so when you don't have status at all. And so I think that this is an example of how unfair the immigration system can be. And it sets a high bar for people with precarious status. So establishment looks at how long you've been in Canada, the friends you have here, whether you have family in Canada, maybe you have a child that's born in Canada, maybe you're in a romantic relationship with someone in Canada. This part looks at whether you are working or self-supporting. It's important to understand that if you're taking Ontario Works, your application will most likely be refused. It can also, consider whether you're a part of community organizations, volunteering, going to church, or some other faith-based organization. Maybe you've taken a course, studied a bit, or received a workplace certification. That's all relevant to establishment. At the end of the day, immigration wants to be confident that if you are granted permanent residence, you will work hard and pay your taxes. I mean, it's a capitalist country, as many of you are intimately aware of. When I do an application for someone who's working, I like to provide a very detailed overview of what a typical workday looks like to demonstrate how hardworking that individual is. Again, I think it's unfair to have to market yourself that way, but this is what it's like to work within the system. Now, moving on to hardship. This looks at what your life would be like if you had to return to your country of nationality. A hardship is different than a refugee claim. That looks at risk and asks, will you be hurt or killed if you had to go back to your country of nationality? And would you be hurt or killed because of something that's specific to you? For example, because you supported the political opposition and now people in government want to silence you. Or maybe a cartel has specifically threatened you and your family. That would be risk, and that would be what a refugee claim would look at. Hardship, on the other hand, looks at how hard your life would be if you had to leave Canada and the difficulties you would experience in your country of nationality. So I've got a few examples here. For example, would you struggle to find a job in your country of nationality because you are over the age of 40 and there's a lot of age discrimination in the job market? Another example is there a lot of criminality in the city you're from, but you wouldn't be able to find housing elsewhere? Another example that's very common is all of your immediate family might live in Canada and you don't have close family in your country of nationality. These are all things that would help demonstrate hardship. In addition to establishment and hardship, there's three other common factors that require special treatment when immigration is assessing your application. And they are medical conditions, psychiatric evidence, and the best interests of the child. In terms of medical conditions, this would be something that is raised if, for example, you have a medical condition that cannot be treated in your country of nationality, or that would be extremely costly because you would have to pay privately to treat it. Or perhaps you have a medical condition where you would face discrimination, and because of that discrimination, the discrimination would cause a barrier to you seeking out and obtaining medical treatment. So this is a very common and relevant factor for people who are living with HIV and AIDS. In terms of psychiatric evidence, did you experience a traumatic event in your country of nationality? And would returning to your country of nationality cause you psychological distress because of that traumatic experience? Or do you have a mental health condition that was not treated in your country of nationality because there's discrimination against people with mental health conditions? Psychiatric evidence must be treated with special care by an immigration officer. And the last thing is the best interests of the child. And this is a very important factor, and it is addressed quite a bit by the courts. Immigration officers are required by law to assess this factor with a great detail of care. The immigration officer who is assessing the application must ask, what is in the best interests of a child or children who will be impacted by the outcome of this application? The child doesn't have to be yours. It can be any child. But you must demonstrate how they will be impacted by the outcome of your application. So, for example, you have a child who is born in Canada, and if your application is refused, you may be permanently separated from your child because the other parent has permanent status in Canada. Another example, you're working in Canada and sending money to your child who lives in your country of nationality, and that child, your child relies on your income for housing, education, food, all of their basic needs. The officer must identify that it's in your child's best interests for you to remain in Canada so that their basic needs are met. Because if your application is refused, you may not be able to financially support your child. Another example, you are one of the primary caregivers to your niece or nephew, so that their parents, and your caregiving allows their parents to work. They can't afford daycare or to pay for another caregiver. The officer must identify that it's in your niece or nephew's best interests that you remain in Canada as their caregiver, and that without you, their family would be significantly impacted. Now, Ultimately, all of these factors, hardship, establishment, best interests of the child, medical conditions, they're all weighed, um, and the officer must explain why or why not those factors warrant granting your application for permanent residence. And so the reasons that the officer provides are also very important. So just to conclude and to summarize, agency applications are really broad, and there's an unlimited amount of things that you can raise and evidence that you can collect to support your application. And in addition to being broad, they're also very specific. They're specific to you as an individual. So it's really important to provide as much evidence as you can. And it's also really important to work with someone such as a lawyer because they can be really complicated. And again, because they have a really big impact on your life. All right. So that's the end of my talk. If you have any questions, I'm happy to answer them. I see there's a couple questions, but I'm not sure I understand them. And sorry. So I have a question here. I was introduced to the agri-food. Okay. Okay, so that question has been answered. So there is, Chris has provided a link to a pilot project for agri-food. So I'm assuming that that's in whatever chat of whatever platform people are viewing. Okay, another person asks, what are your chances of getting permanent residence through these applications? So everything is very specific. I think I have seen, the acceptance rates fluctuate, so sometimes around 60%. But whomever you're working with will give you a better understanding of what the strengths and weaknesses of your application. So you can submit multiple, but there's some bars on when you can submit your next one. For most people, you have to wait 12 months before you can submit a subsequent application. But again, in terms of the merits of your specific application, whomever's assisting you will be able to give you a better idea. And if somebody tells you, oh, don't worry, you're going to be fine, ask for a second opinion. So here's another question. I am from Baird's, working on a close contract to a hotel, and due to COVID, we were laid off and we were unable to receive EI due to the close contract. Oops, it's disappearing. Sorry. How can I apply for an open work permit? Okay, so if you'd like to speak about that, you can contact me. Oh, okay, and then also Chris has also responded and said, you can also contact Justice for Migrant Workers to discuss EI in more detail. Okay, how long does it take for these applications to be processed? That's a great question because there is no clear answer to that. They can be processed really quickly. Other people wait years. So if you've got one in, you just have to sort of understand that it can take a really long time, or it might take a short amount of time, which is why it's really important to get all of your evidence collected and have a really fulsome application and submit it. And then to provide updates every 6 to 8 months. You want to make sure that the officer who's assessing your application has everything that you want them to consider. So say, 2 years have gone by after you submitted your application. Well, I'm sure things have happened in your life. And so it's important to provide an update. Okay, another question. How many years do you have to be working in Canada to apply for permanent residence for my son and I? Well, first thing is you don't necessarily have to be working at all, but it's a good thing if you are. And it's very fact specific. And so if you have, for example, compelling hardship factors, and your son, your child, it will be affected in some way if you had to return to your country of nationality, then you should apply, as soon as possible. It's often best to have been in Canada for at least a couple years. But again, since these applications are considered holistically, so all of the factors are considered, the length of time you are in Canada, say you've only been in Canada for a short amount of time, it is possible that that could be offset by other really strong and compelling factors. So again, sorry, this is another non-answer to your question. And again, it would be beneficial if you are considering making this application to sit down and have a consultation with someone, and they can give you a good idea of whether now is a good time to submit your application or whether you should wait a bit longer. Yes. So again, the same person said that if they did return to their country of nationality, that they would not have a job to go back to. So another question is, what if I don't have children but still want to file for PR? Well, that's fine. People who don't have children also make these applications. Again, it's sort of looking at you, your entire story, your entire picture, and all of your circumstances. So obviously, having a child can make your application strong. But that doesn't mean that if you don't have children, your application will not be strong. Okay, so another person says, I wanted to submit an application shortly, but was told that the immigration office is closed. Any idea when it will open? Well, actually, the immigration offices are open, and I've been submitting these applications. You can submit it whenever, the person who is assisting you says that, your application is ready and should be submitted. So you can submit it at any time. They're not closed, but I do think that COVID is impacting processing times. So it could make these applications, it might take longer for these applications to be decided. Okay, And then another person asked, what do I have to do to submit my application? Well, I mean, the first thing that you should do is to find either a lawyer or a paralegal or consultant or someone who can sit down with you, get a sort of a picture of your whole story and your reasons for seeking permanent residence, and guide you through the process. Okay. Um, okay, so another person asks, what percentage of applications are successful? Again, they fluctuate, but I think, and immigration also does not publish these numbers, so this is just a guess. I don't take it with a grain of salt. It is a guess. I think about 60%, sometimes higher, sometimes lower. Okay, so um, any other questions? There's another question about open work permits. Um, Again, I think this was asked by somebody who doesn't know whether they're eligible for an open work permit. And so I'm happy to chat with you off list to sort of get an understanding of your situation, and advise you. Um, okay. So, another question: what if I submit an application and I lost my job in the process? How would I go about another job without having an open work permit? Now, here's the complicated thing: is that on the one hand, and this also speaks to the unfairness of these applications. Um, on the one hand, immigration wants to see that you're self-supporting and that you're not on welfare. But then on the other hand, because they're often made by people who are not authorized to work in Canada, um, that's a pretty tough position to be in, right? And so I have had clients who are working without a work permit, and it's important to just be open about that in your application, and it's important to be open about that in your application, um, and to provide an explanation for it. Maybe, for example, maybe you're working because one of your parents back home has cancer, and they cannot afford to pay for treatment because the healthcare system there's no public healthcare system. That would be a compelling reason as to why you have to work, because um, you're sending money to people back home who are dependent on you. So it's just really important to be open about your life, and what you're doing, and just to provide reasons why. And whomever is assisting you with the application will guide you through on how to provide that explanation, and how to be open about unauthorized work. All right, and another question. Good evening. I lost my status in 2018. I worked in the service industry. Do I have a chance if I apply for an HNC? So, um, again, because these are just so case specific, it's I can't really say. But what I would say is that it sounds like you've been here for a while. You were working, um, and it would be a good idea, I think, for you to speak with a lawyer to get a better picture of, again, your establishment and your hardship. And the lawyer or whomever can guide you through the process and give you better advice on what the strengths of your applications are and what the weaknesses might be, and then how to strategize around those strengths and weaknesses. Okay, so another question. What are the chances of having a successful application in the LGBTQ community, married in Canada, but don't want to go under the refugee scheme? So, I mean, just, on the face of it, what I would also suggest considering is a spousal sponsorship. If you are married to a Canadian citizen or permanent resident, um, there's pros and cons to sponsorships as well. If you are interested in instead pursuing a humanitarian and compassion application, again, I'm really sorry to keep saying this, but it would be good to sit down with somebody, and they'll ask you questions to get sort of a sense of your life in Canada and the hardship and difficulties you might face if you had to return to your country of nationality. For example, if that country is really homophobic, or if being queer is against the law there, that would absolutely demonstrate hardship. And so, again, it'd be really good to get some legal advice and see, which applications might be best for you and the pros and cons of each. Okay, so another question about an open work permit. So the form is online, but again, I think it'd be a good idea to chat with a lawyer or seek advice from a legal aid clinic about your work permit, just about getting a work permit. I think somebody messaged on WhatsApp, so I'm just checking my phone. Oh, okay. All right. So, any other questions? Okay. All right. So, okay. So, if you have questions about your open work permits, you can contact Chris on WhatsApp. And I'm assuming it's okay to read out your number. Um, please tell me. Okay. 647 834 4932. All right, well, this was really great. I cannot see any of you. Um, it was sort of like talking to myself, but it was really great. Your questions were fantastic. If you have any other questions, please let me know. You can message Chris on his WhatsApp number. Oh, sure, I'll repeat the number. It's 647 834 4932. Okay, an excellent question. Do you have any idea what the cost looks like to do these applications with a lawyer? And my goodness, that varies. Uh, if a lawyer is trying to charge you $10,000, do not work with that lawyer. You should definitely try to see if you can get legal aid funding for your application. And then if not, you can see, some lawyers, they provide payment plans. So, they might give a fee, but then say, well, you can pay me over a period of however many months. But yeah, so I mean, the costs if you're paying privately do vary. But I'll say if you're being charged $10,000 or around that amount, not a good idea. Okay, so another question is, if your agency is denied, what options are available to you? Well, um, you should absolutely seek legal advice, because oftentimes when these applications are refused, the officer made errors, um, or did not assess it reasonably, or did not, apply the correct analysis. These are officers. They're not judges. They're not board members. They work for immigration. They're, gatekeepers. So you should absolutely seek legal advice right away. And there's a possibility that you could make an application to the federal court for something called a judicial review. And a judicial review is when the judge looks at the officer's decision, then what was before the officer, so your evidence, and that's why your evidence is just so important. And then it looks at your lawyer's, and then the lawyer who's assisting you with the judicial review will then write, legal arguments about why the decision was wrong. And so then the court will consider all of that and say, either, no, I think, based on what was before the officer, this decision is reasonable. Or the court might say, well, you know what, this officer really did not consider the best interests of this person's child. So this decision is unreasonable, and I'm going to send it back to a different immigration officer to assess. So that is one option. Another option is to wait and then make another application. Okay. I didn't quite understand this question. Do you all have your own lawyers to deal with migrant workers? If the person who asked that question could provide a bit more info about what you mean by that, that would be great. Okay, another question. If I start the process and my time here in the country is up, what happens from there? Well, the reality is that these applications are made by people whose time has been up years ago. So they're here without status. So these applications are geared specifically to those people. Your lawyer will speak to you a bit about, what you should do if your time is up. I will say that if you have one of these applications in process and then you leave the country, your application will most likely be refused, and that's because it looks at establishment in Canada, and hardship in your country of nationality. So if you're not in Canada, it's difficult to demonstrate hardship. If you are living and surviving in your country of nationality, it's again difficult to demonstrate hardship. If your application is weak, how can I strengthen my application? That's really specific to you. So whomever is assisting you will tell you, what the weak parts of your application are, and then they will give you some advice on how to make that part stronger. So yeah. Does it make a difference to work with an immigration lawyer or a lawyer outside the system? I would absolutely work with an immigration lawyer because they know immigration law. It's sort of like if you have a criminal matter, would you want somebody who does corporate law to assist you with, your criminal defense? You should get a lawyer that specializes and is knowledgeable of immigration. Okay, so another person says, I have some questions but would like to do so personally. Is there a way I can reach you? Um, I will put my email in the private chat, and then maybe somebody could assist me with sharing that. And then there's another question. In your opinion, will Canada give people without status an amnesty program? I mean, in my opinion, uh, I don't know how valuable my opinion is on that. I mean, it's great to hope and to keep pushing for status for all. It's also important to understand, the system and the country and the history of this country that you're, um, you know, advocating for that within, right? We're a settler colonial society. Um, okay, and so if you would like to contact me, just also get in touch with Chris. Another question, if my application has been refused, can I reapply, and how long do I have to wait before I can? So this is a good question, and it's my answer. I'm sorry, it's going to be another one of those non-answers. So it would be very specific to you, and it would be very specific to what your first application looks like. If your first application, maybe it was very poorly done and not a lot of evidence was provided, and there's so much more, so many more factors that could have been assessed, but they just were not before the officer. Then, I would, maybe explore the possibility of submitting another one, as soon as you can. As soon as you can is also specific. There's a rule that you have to wait 12 months since your last refusal, but there's some exceptions to that. So one exception is if a child is affected by your application, so best interests of the child. Another exception is if you have a medical condition, and if you were, removed or deported, that you would suffer due to that medical condition. So again, it's specific to one, whether you meet those exceptions to the 12 months, and two, what was in the first application. Yeah, and exactly what Chris says, regarding an amnesty or status program, we still need to fight for this. Exactly. Yeah. It's going to be a tough fight, but absolutely. Okay, so if there's no more questions, we can start wrapping up. Thank you to everyone. And these were really great questions. Thank you for having me. Thank you for spending this time with me. And again, reach out if you have other questions.